Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 17 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between October 7th, 2020 and October 13th, 2020. We'll begin today's case law update with a couple of civil cases. In the case of Povax versus the Pennsylvania Public Utilities Commission, several consumers appeal a decision from the commission denying their request to prohibit the utility company from installing wireless smart meters on their homes due to the potential risk for harm from RF emissions. The administrative law judge held that Act 129, an amendment to the Public Utility Commission that directs that companies shall furnish all homes with smart meter technology, precluded the commission from considering alternative remedial measures as requested by the consumers. The Commonwealth Court found that while Act 129 does require utility companies to furnish smart meters, the code does not state anything requiring that consumers accept the smart meter. Because the Public Utility Commission relied on their belief that alternate remedial measures were not permissible, none were considered. The Commonwealth Court remands this case to the Public Utility Commission to determine whether accommodations are appropriate for each consumer, and if so, what those accommodations should be. The Commission should consider all reasonable accommodations. However, in determining whether accommodations are appropriate, the consumer bears the burden of proving harm, and evidence that smart meter may pose a risk of health is insufficient. James v. PennDOT is an appeal following a denial of a statutory appeal where James challenged the downgrading of his commercial driver's license, or CDL license, to a non-commercial Class C license. In this case, James received his CDL after passing a skills test administered by Luzerne County Community College. Following his test date, an investigation revealed discrepancies in the testing protocol, and the community college was decertified as a CDL testing site. 177 CDL drivers were notified that they were required to retake the skills test. James failed to retake the test despite repeated notifications that it was required. His license was then downgraded and he appealed. The court found that it was proper to require a CDL driver to retake the test when the department has reason to believe that the driver cannot exercise ordinary and reasonable control in the operation of a commercial motor vehicle. Due to the discrepancies in the testing at the community college, the department had reason to believe that those drivers called upon to be retested may not have had the ability to exercise ordinary and reasonable control, and therefore, when James failed to retake the skills test, it was proper for the department to downgrade his CDL. Next, we have a criminal law case. In Commonwealth v. Johnson, the defendant was convicted following a jury trial of first-degree murder. During the trial, the Commonwealth introduced into evidence text message records between the defendant and the victim, as well as additional evidence discovered from the defendant's cell phone. The defendant presented expert testimony regarding the substances found in the victim's blood to establish his state of mind at the time of his death, and a second expert to testify to the defendant's diagnosis of PTSD to establish a claim of self-defense. On appeal, the defendant raised several evidentiary claims, the first being whether the text messages were properly admitted. The court found that as a preliminary matter, the defendant did not contest the authentication of text messages, which is often the biggest hurdle to overcome when relying on text evidence. He instead claimed that the victim's text messages were not subject to any proper hearsay exceptions. The court found that the defendant's texts were properly admitted as admissions of a party opponent, and that the victim's texts were admitted not for the truth of the matter asserted, but rather to add context to the defendant's texts. Further, the defendant testified at trial that he believed he was in fact texting the victim at the time. For those reasons, the court found the texts were properly admitted. The second issue involved a photograph found on the cell phone. The Superior Court found no error and held that the Commonwealth presented sufficient evidence to authenticate the photograph, and what weight to give to the evidence was for the jury to decide. The third issue involved the court limiting the scope of the defendant's expert witness's testimony. The court found no error and that the scope of each expert's testimony was properly limited to the substance and facts contained in their reports. In his fourth issue, the defendant claims the trial court erred by allowing a police officer to testify regarding blood spatter when he was not qualified as an expert in that field. The Superior Court found that the officer's opinion was proper, as the officer was permitted to offer an opinion as to how the blood droplets were transferred to their site of discovery. Further, even if there was error, it was harmless, as there is significant cumulative evidence. The defendant's last two evidentiary claims were found to be without merit and irrelevant. In his final issue, he claims the trial court erred by denying to instruct the jury separately on self-defense and the Castle Doctrine. The jury was instructed on both self-defense and Castle Doctrine, but in one single instruction. The court found that this was proper, as Section 505 is the law governing both self-defense and Castle Doctrine in a single rule. The instruction provided by the trial court accurately described the law and closely tracked Section 505. In conclusion, the Superior Court found that the defendant is not entitled to relief on any claim. The court decided two family law cases this week. First, the case of the adoption of BGS addresses whether or not an appeal from termination of parental rights is without merit so as to allow counsel to withdraw. In this case, mother gave birth to a child in January of 2019. Father did not learn about the birth of the child until April or May. By that time, the mother had given up the child for adoption. The adoption agency filed a petition to terminate father's parental rights after learning of his existence, and that petition was granted. Father wished to appeal, and his counsel filed an Anders brief, which is a brief that outlines the procedural history, the possible issues, and why counsel believes those issues are without merit. In this case, the issues involved whether there was a proper evaluation of father's attempts to be involved in the child's life for the requisite 6 months prior to the termination as required by statute. Here, the court found that based on the record, while the father may not ultimately be entitled to relief, there is some merit to his appellate issues. Therefore, counsel's petition to withdraw is denied, and counsel is directed to file an appellate brief on the issues. In re, the interest of YWB is an appeal by mother following the trial court's order compelling mother to comply with a home visit by the Department of Human Services, or DHS, and that she is not permitted to record the DHS workers during the visit. On appeal, mother argues that the DHS lacked probable cause to necessitate a home visit and that the order prohibiting her from recording the DHS workers is a violation of the First Amendment. An agency may obtain a court order compelling a parent's cooperation with a home visit upon a showing of fair probability that a child is in need of services and that evidence relating to that need will be found inside the home. In making a probable cause determination, the trial court may consider evidence presented at a hearing on the petition, as well as the court's and the agency's prior history to the extent that it is relevant. In this case, the court found ample probable cause supporting the court order to comply with the home visit. In regards to the First Amendment claim, the court finds that the prohibition of recording is subject to intermediate scrutiny. A blanket prohibition is not permitted under the First Amendment, but may be subject to reasonable time, place, and manner restrictions. Up next, a property case. Osavala v. Gaudet is a property complaint whereby Osavala is complaining that Gaudet improperly filled his property without permits, and such fill on the property, which is a floodplain, caused direct damage to the Osavala's property. The Gaudets filed preliminary objections, claiming that the issue was not proper before this court because it was an issue that had not yet been resolved by the zoning board. The trial court granted the preliminary objections, and this appeal followed. The Commonwealth Court found that by statute, issues involving floodplain management need not be first addressed by a zoning board and are proper in either the Commonwealth Court or a court of common pleas. For that reason, the trial court order granting the preliminary objections is overturned, and the case is remanded to the trial court. In the final case of the week, we have a probate case. In re Jabor is a probate case regarding whether a spouse can revoke her election to take against the will an allocation of funds regarding the spouse and children of the decedent. Pursuant to Pennsylvania law, a surviving spouse has a right to an elective share of 1/3 of certain property of the deceased. The statute provides a procedure for a surviving spouse to elect whether or not to take this share. The surviving spouse must notify the clerk of orphans court, and it must be filed within 6 months after the decedent's death, or 6 months after the date of probate, whichever is later. If there is no election filed in the time frame, it is deemed a waiver of the right to election. In this case, the surviving spouse filed the election in an abundance of caution because she did not have sufficient information about the decedent's non-probate assets. Upon learning full information regarding his assets, the surviving spouse revoked her election. The law states that if an election is made with full knowledge of all essential facts, it cannot be withdrawn. However, if not all the facts are known, the election may be retracted upon discovery of the facts. As that is the case here, the election could be revoked even though it was outside the statutory 6-month time frame. The second issue in this case involved the decedent's daughter's claim that she was entitled to funds that were taken by the surviving spouse. However, the lower court did not rule on that argument, and therefore the issue is not ripe for review by the Superior Court. The third issue involved a reimbursement to daughter for funds spent on decedent's care prior to death as well as funeral expenses. When filing her appeal, daughter provided a reproduced record but failed to include the documents that were admitted regarding reimbursement. As such, the court finds the daughter waived her claims on those issues. That does it for this week's cases. Thank you again for joining us, and have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.